Welcome to our data protection bite-sized podcast. And today we're going to look at some of the enforcement actions taken recently by the Information Commissioner's Office, both under the old legislation, that is the Data Protection Act of 1998, and the new legislation, the Data Protection Act of 2018. The first type of enforcement action we're going to look at is in relation to the payment of the data protection fee. Under the old 1998 Act, there was a requirement that businesses that collect personal data pay an annual registration fee to the ICO, and that was £35 for small and medium businesses and £500 for large businesses. Now that fee was replaced under the new legislation, and there's now a requirement to pay a data protection fee under the 2018 Act, unless an organisation is subject to an exemption under the legislation. And the legislation covering that is now the Charges and Information Regulations, and that replaced the requirement to register with the Information Commissioner's Office under the old 1998 legislation. If we look at the different categories of organisation, Tier 1 caters for micro-organisations which have a maximum turnover of £632,000 per financial year, or no more than 10 members of staff. And the fee for a Tier 1 organisation is £40, and so that's fairly similar to the old registration fee under the 98 legislation. Then moving on to Tier 2, and that's a fee for small or medium organisations which have a maximum turnover of £36 million per financial year, or no more than 250 members of staff. And the fee for a Tier 2 organisation is £60 per annum. Then for larger organisations, and that is organisations that don't fall into the Tier 1 or Tier 2 category, the fee payable is very substantial, and that's £2,900 per annum. And so if you compare that with the maximum registration fee under the old legislation of £500, it's a fairly significant jump. So as I've said, there's some exemptions under the legislation, and a fee isn't payable if an organisation is processing personal data only for one or more of the following purposes, and that is staff administration, advertising, marketing and public relations, accounts and records, not-for-profit purposes, family or personal affairs, maintaining a public register, judicial functions, or processing personal information without an automated system such as a computer. And one of the recent cases involving the failure to pay the fee involved the company Fire & Ball. That's the paint and wallpaper company. Unfortunately for Fire & Ball, a combination of the person responsible being on holidays and personnel not appreciating the seriousness of the correspondence from the Information Commissioner's Office resulted in them being levied with a fine for failing to pay their Tier 3 data protection fee of £2,900. So Fire & Ball should have paid the fee, and when it failed to do so, following a reminder from the Information Commissioner's Office, they were then issued with a fine of £4,000, which is quite substantial, bearing in mind that the maximum fee that can be levied by the ICO for failure to pay the fee is £4,350. Fire & Ball appealed the decision to the First Tier Information Tribunal on the basis that the ICO's reminder was sent while the relevant Fire & Ball personnel were on holidays, and then the correspondence was not identified as important. And then when they did discover that the fee was payable, it was paid immediately. The tribunal, however, found that Fire & Ball should have had proper systems in place to ensure that the fee was paid, and also they hadn't pointed to any particular hardship that could affect the penalty, and therefore the tribunal didn't see any reason to depart from the original assessment, and so the fine of £4,000 still stands. Now, whilst the fine itself won't have a huge impact on Fire & Ball's profits, it was a decision that was reported widely in the media, and I suppose it demonstrates that even where there is a purely technical breach in relation to the fee, the ICO does have enforcement powers and it will take action and issue fines. Interestingly, whilst the ICO uses the fees to fund their data protection work, it doesn't actually keep the fines and passes that money directly to the government. So the £4,000 in terms of the fine went directly to the government and didn't go back into the ICO. Moving on then to look at another type of enforcement action, which involved the company Bounty. Bounty is the parenting club that offers support and advice to new parents who sign up through his website, and they also recruit through the maternity wards, and so Bounty people will actually approach pregnant mothers and new mothers on the maternity wards. They were recently fined £400,000 for sharing data with a number of marketing agencies without any consent from parents. And the reason why I mentioned this example is that the figures involved in this breach are staggering, given that between June 2017 and April 2018, Bounty shared 34.4 million records with 39 organisations. So this is a massive breach in a sense. The ICO highlighted that the sharing was aggravated by the personal nature of the information about potentially vulnerable new mothers and mothers-to-be and very young children. And so that was perhaps another reason for the fine being at the level it was issued. Now, this fine was issued under the old legislation because this breach happened before the 25th of May 2018, and so the fine was subject to the limit under the old legislation, which was £500,000. However, if that breach had happened under the new regime, it's likely that the fine would have been far greater. And so Bounty were lucky in a sense that the breach happened before the 25th of May 2018, because under the new legislation, as you probably know, the maximum fine that can be issued is up to a maximum of €20 million. Now, the ICO did comment that the amount of data shared was unprecedented, and that Bounty's actions appear to have been motivated by financial gain, given that data sharing was an integral part of their business model at the time. Whilst Bounty admitted fault in sharing the data and said their data sharing processes were not robust enough, it went on to state that these were historical issues which have now been addressed, and they stated that they continue to provide a valuable service to new parents that's both helpful and trusted, and so they didn't issue an apology as such. Bounty isn't the only parenting club to have been subject to an ICO fine, and one of Bounty's competitors, called Emma's Diary, received a fine of £140,000 in 2018 for passing data to Experian on more than 1 million new mothers. So it was a breach that wasn't as widespread, didn't involve as many data subjects, hence the fact that the level of the fine issued to Emma's Diary was lower, but it was still a substantial fine of £140,000. So to sum up, really, the ICO is an organisation with significant enforcement powers, and it's not afraid to issue fines when necessary. In 2018 alone, it issued 103 monetary penalties for non-payment of the data protection fee, and of those penalties, 16 organisations were fined £4,000. So it reinforces the need for organisations to first of all establish whether they need to pay the fee, and secondly to make sure that the fee is paid on time. Many of the other monetary penalties which have been issued against the likes of Facebook and Uber, and as outlined today, Bounty, were in relation to a pre-25 May 2018 breach, and so the fines levied fell under the old legislation, that is the Data Protection Act of 1998. I think as we see breaches happening under the new legislation, we're only going to see an increase in fines, and so watch this space, as there's likely to be more publicity in relation to substantial fines going forward.
This conference will now be recorded.
So thank you for listening to today's podcast. If you have any data protection queries, feel free to contact me, Aisling Byrne, at Cleaver, Fulton, Rankin, or my colleague Michael King, who also specialises in data protection.